Welcome in, guys. It's me flying solo to start here tonight, but it's Thursday, June 17th, 2021, and we have a really interesting interview tonight. We did have to film it last night, so you'll see I'll be wearing something different, but our guest tonight is Colorado attorney Heather Mitchell. Now, I wanted to have Heather on because she has a very unique background. So not only is she married to a single father who has been through the system, she has a very traveled background as an attorney. She's a former public defender, federal public defender, and she has actually presided over cases as a judge for 2 tribes in the Western United States. Now her practice primarily consists of family law, and over 80% of the cases that she represents men. And like I said, she has a very unique background in terms of perspective from her husband and from her time as a public defender and being on the bench. So this interview was recorded last night. So I got my phone out. I'm going to be very active in the chat tonight. Still drop your questions. Once the video gets done, I will hop back on and I can answer a few questions before we end the episode for this week. So now I'll turn it over. It'll be an interview with myself and Colorado attorney Heather Mitchell. All right, Heather, thank you for joining us tonight. So you're coming to us from Colorado Springs tonight?
Actually, Monument, between Colorado Springs and Denver.
Okay, awesome. So we'll go ahead. We're going to hop right into our first topic for tonight. And that topic's going to be, what do we got going on in terms of laws in Colorado? So those of you that have watched us every week know I always like to cite the National Parenting Organization's state grades. So 3rd week in a row, we have a C. So the state of Colorado grades out as a C on their scale. And to give some context, there are about 25 states, or there are 25 states in the 2019 survey that have a C-, C, or C+. So Colorado falls firmly kind of on the fence in terms of not good, not bad, in terms of equal and shared parenting laws. The biggest negative is there's no statutory preference or presumption of shared parenting, and the statutes do not explicitly provide for shared parenting, specifically during temporary orders. So Heather, you're on the ground during in court in Colorado. What's your take on the laws, and how do they actually play out in the courtroom?
So I would agree with you as far as temporary orders. Unfortunately, a big part of the problem here in Colorado, I would say, is that the dockets right now are really overloaded. So when you're looking at a temporary orders hearing, I'll be lucky if I get 20, 25 minutes to present my side. Judges typically set the entire hearing for an hour. I do think it gets a little better as we get towards permanent orders. I do think that, while it's not statutory, I think most judges here do strive for 50-50. That's what people hear. That's what we say all the time. People want to see 50-50 custody. That's the perfect world. Sometimes it's hard to get there. I'm not going to lie. The other thing in Colorado, basically, I'll break it down the way it works in Colorado. When you're dealing with custody matters, it's either going to be part of a dissolution of marriage or what we call an APR, which is an allocation of parental responsibility or parental rights. So you're going to have an initial status conference, which usually is not even with a judge. You're going to get set for certain deadlines. Mediation is absolutely required in Colorado. It's very hard to get out of the mediation requirement. Then you've got temporary orders and permanent orders, and that's pretty much it.
So one thing I was aware of that I actually really like about Colorado is their terminology around child custody.
Mm-hmm.
So the parental responsibility. So do you see that compared to, I know you've been really all over the country practicing law. Do you see that making an impact, just the terminology?
I do. The fact that we talk about parenting time, we don't talk about custody really. It's about time spent with your children. And that's what it should focus on. And really the focus in Colorado courts, statutorily speaking, is supposed to be what is in the best interest of the children. So obviously, there's different ways to get there and different ways to present your case, but ultimately that's what the court is to consider, is what is in the child's best interest, not the parents, not necessarily what the parents want, but what's best for the kids. And that's what the focus should be.
Yeah, definitely. Completely agree with that. So where is Colorado in terms of the statutes and how they handle domestic violence accusations?
So Colorado goes a step further. When we talk about, so we've got parenting time, which is the actual time spent with your children. Then we talk about decision making, which is separate. Decision making is things like religious upbringing. Where are they going to go to school? Who's going to make the decision on whether your child has braces or goes to a dermatologist or whatever? So we break it down into different categories. Where domestic violence comes into play is if there are allegations of domestic violence, a court can say that they can't have joint or shared decision making and can award, and that's usually where it comes into play, is one person gets all of the decision making because of, and remember, it's allegations of domestic violence. Doesn't have to be a conviction.
Yeah, we got something similar talked about on previous episodes. We got Family Code Section 3044. It's not beyond reasonable doubt like we find in criminal court. It's preponderance of the evidence, and California actually goes a step further, and there's a presumption that the parent found to have the credible allegations are against should not have any sort of legal or physical custody. They essentially go straight to a limited visitation.
So where it comes into play in Colorado is not necessarily the parenting time. So I've had plenty of clients where there have been domestic violence allegations between the parents, but the children haven't been affected. And so I've had judges say, well, you know what, until you get off of probation or, your deferral is finished, I'm not going to order joint decision making, but you're still going to get that parenting time. You just don't have to communicate about decisions. But that can change, and I've had cases where the judges have said, okay, you can do a modification and we can talk about decision making in a couple years. I've also had judges find that even though there were allegations of domestic violence, they thought that it didn't rise to the level where it would affect decision making, and they thought that the parents could still make joint decisions together.
So there's quite a bit of judicial discretion. Do you see them err on the side of caution when it comes to those DV allegations, or do they say, hey, we want both parents involved if the children aren't impacted by this domestic violence?
It really depends on the judge, and in Colorado, it's very fact specific. It's going to depend on the type of domestic violence allegations too, whether there's a pattern of domestic violence. Is this, maybe it's a one-time incident, something happened, whatever. And the reality of Colorado law is anything can be domestic violence. They attach what we call a DV rider. So you can have criminal mischief, for instance, and if the prosecution thinks that it's been done for the reason, to intimidate, control, something like that, then they can add that domestic violence rider. And so that criminal mischief conviction that now becomes a domestic violence conviction.
Gotcha. So we see the criminal courts actually impact what goes on in family courts in Colorado.
Yes. Yeah. In some respects. Yeah.
That's interesting. Is there anything else of kind of note in Colorado in terms of that fathers should be aware of?
I don't think so. I think for the most part, most judges do a pretty good job. Under Colorado law, they're not supposed to consider the gender at all of the parent as to whether the parent is fit or not. They're supposed to, even when kids are young, they're not supposed to, there's no tender age doctrine, anything like that women are, per se better parents. So I think that's good, but it really is very fact intensive in Colorado. So I think, my advice would be to make sure, at least have a consultation with a lawyer who can help you organize those facts and present those facts in a way that the judge is going to listen to.
Awesome. Yeah, perfect. And that segues perfectly into, we're going to start talking about some legal stuff. So I have an attorney disclaimer. I'm barred in the state of California. Heather's barred in the state of Colorado, and I believe Florida as well.
Florida as well, yeah.
Yeah. But nothing we say tonight in regards to our legal opinions should be construed as advice. It's simply educational, and nothing is better than being able to talk to a family law attorney in your state. Nothing we say or do should be construed as an attorney-client relationship being formed either. We're here to educate you guys tonight, and that is it. So, moving on to our second topic, you have a very, very interesting background. The criminal defense, the public defender aspect of it is probably most interesting to me, but that's probably the legal nerd and like what you bring to the table. I think our dads would probably be most intrigued by the fact that you have actually presided over both criminal and family cases as a chief judge of 2 tribes in the Western United States. Yeah. So what did you gain in terms of experience? How did that open your eyes in terms of presiding over these cases?
It was very eye-opening to see how lawyers behave, number one. And just to, learn, okay, and start thinking about why did this argument resonate with me over a different argument? It's definitely different sitting up there looking down on people and judging people. I mean, it's a weighty responsibility. That's what I'll say.
Yeah. So going along the lines of that, you mentioned why, like looking at attorneys, why did they act this way? Why did they do this? What advice or what insights would you have for dads based directly on that experience?
So this is another why you should talk to a lawyer and hire one if you can. Take the emotion out of it, which is really, really, really difficult. I've even represented lawyers in their own cases, and they have a hard time taking the emotion out of it because when you're in it and you're that emotional, it's number one, it's hard to see clearly because obviously this is the most important thing to you probably ever in your entire life. And so number two, it's hard to focus on facts, and you start to focus in on things that might not necessarily be important. And I say that in quotes because I know to my clients, those facts are very important. But when I'm looking at it from a legal perspective and how to present it to the court, those are facts that the court is not going to, they're either not going to resonate with the court or the court's not going to see it the same way. Does that make sense?
100%. I think that's a really good way of putting it. I put it this way to my clients. There are really 3 pieces to your custody case. You have the mental piece of it. That's the most important piece. You got to get that right. That's the emotion. That's dealing with all the emotions and everything you're dealing with internally. And then there's the strategy piece, and then it's the execution piece. But if you don't get that mental side right, you're not going to be able to clearly put together a coherent strategy, and there's no way you're going to step in a courtroom and execute on it. So getting that mental, getting those emotions in check. I always advise guys, I say, hey, you can call me and talk to me at any time, but go find yourself a good therapist. They're much cheaper, and they're trained to do that.
Exactly. Yeah. And it's difficult. This is, these are emotional cases. And the reality is, at least as far as dissolution is concerned, Colorado is a no-fault state. So the judge doesn't care about what people care about a lot of times when they're going through a divorce. They just want to hear facts and law.
Yeah, the telling the guy that it doesn't matter anymore that his wife cheated on him can be very challenging to them. Yeah. So kind of along those lines, outside of that emotional piece, sitting on the bench, looking down over these, presiding over these cases, what were some of the most common mistakes you saw men make?
Probably emotion, number one. Anger, especially. There's a lot of anger. I think, men especially tend to deal with emotion more as anger, whereas women are the ones who are breaking down in court and crying. That said, I will say that for men, it's okay to cry in court. It's okay to show emotion and that you really, really care about your kids. I know for a fact that resonates with judges and that they can see that. I mean, judges are human too. So that would probably be number one is, exhibiting any type of anger, especially if someone's making allegations of domestic violence against you. You don't want to, that's, low-hanging fruit that, is easy for a judge to grab on, and you don't want to do that. I think too, what's really hard for a lot of people is setting aside what they want and really thinking about what's best for the kids, which the reality is, what's best for the kids is if everybody can act like adults, get along, and all be on the same page and raise this wonderful human being that you all brought into the world. And that's hard. It is hard to put that aside. But I do think that, I know that resonated with me when I was on the bench, and I've seen it, with judges here in Colorado, that they can see that dad is, taking the steps and you know what? And some of it is red tape and jumping through hoops, but that shows the court that you are making that effort. And I think, that's something a lot of judges want to see is, you might not agree with my order, but you understand that it's an order and you're going to follow it and you're going to make that effort. So I think that's it. I think also expectations. The reality is that these court processes, they're not fast by any stretch of the imagination. And so I think people walk into court and they expect, a lot of times in Colorado, the judge doesn't rule after the hearing. They'll take it under advisement for sometimes weeks at a time. It can take months to get hearings. So I think expectations are part of it too. Go in there, knowing that this is a marathon, and not getting discouraged by that. And that there may be, we always say here in Colorado that there are no winners or losers in family law. Nobody, pretty much, if you're going to go in front of a judge, no one's going to be happy because the judge is going to do something that is going to make you both angry, if that makes sense.
Yeah, that makes perfect sense. So, I always tell my clients the same thing, that it's in California can take anywhere from 6 weeks to 4 months, depending on the county, to get a hearing. And the likelihood in that initial hearing, if you get anywhere near what you want, is extremely small. You have to play the long game. And I thought you made another really, really good point. Effort. I always tell my clients, do something. If the judge sees you're putting in a ton of effort into getting this right, into being the best parent you can be and doing all the right things, they're going to notice that. They may not, it may take some time because they may have 300 cases on their load right now. They're seeing 80 to 100 cases a week in front of them. But if every 3 to 6 months they're seeing you and it's like you've done something more, you've done better, you've taken actions to be a better parent, they're going to start recognizing that pattern, especially if your co-parent isn't taking those steps.
Exactly. And I always tell my clients, let's give the other side enough rope to hang himself. Let's do twice what they do. If the judge tells you to take a parenting class, take 2. If the judge says take, a UA a week, take 3. I think in family law, especially, there's no such thing as overkill on something like that. I think judges want people, for the most part, to be the best parents that they can. And they want to see that they're taking things seriously. And I know, as a judge, there were times when I, maybe had some concerns about drug use with somebody. So I'd say, okay, I'm going to put you on UAs. Here's what I want you to do, get an evaluation, come back in 60 days. And, and there were people who would, oh, that's stupid. I don't have a problem. I'm not doing any of that. Well, if you don't have a problem, I understand that, this might seem stupid to you at the time, but I don't know you. And that's the reality, is the judge doesn't know you. And so sometimes you do have to go a little further to convince them that, hey, I don't have a drug problem. I am not this monster this person is painting me to be. And I'm going to show this to you, judge, because I know you don't know me.
Yeah. They see you. You mentioned hour-long hearings. Out here, short form hearings, you may get 5 minutes, you may get 15 minutes. If you get 45 minutes total, I think I've seen one of those ever go that long. I mean, they don't get to know you. And that's why a lot of times in California, they rely on third parties. They bring third parties in to get to know the situation. I want to roll back to something you mentioned, because I think it's something that is kind of a debate amongst fathers, and I see a lot in the Facebook groups and different things. So the other side set a strategy to paint you as a monster, that you're an incapable parent, you've never been a good father, you drink, you do drugs, and in reality, you would drink beer socially and you smoked weed a handful of times. We're both in states where it's legal. We'll cover that a little bit later. But what would be your advice to fathers when you know the strategy, the other side, what they're going to try to do in terms of being proactive around parenting classes, therapy, getting drug tests done?
So, I mean, I think that there, like you said, all of those things are things you can do to be proactive. And the biggest thing is don't take the bait. Because it is, in some respects, people can only take so much hearing, I'm such a bad guy, I'm so awful, I'm this monster, before there's an anger that comes out. I mean, it's human nature. But you can't do that. You can't buy into it. You can't become the person they're trying to make you be, if that makes sense. But there are things you can do. You can do, if the allegations are alcohol use, sign up for something like SoberLink or BAC Track, and monitor your own breathalyzer testing. Hair follicle testing are things you can do. Things that are going to come up in court, and then you get to that temporary orders hearing, and she's saying, oh, he's an alcoholic, he uses drugs all the time, and you can say, oh, judge, I took a hair follicle test, I've been on SoberLink, things like that. I always tell people too, especially when there are domestic violence allegations of, just any kind of general nastiness, as soon as your case starts, start using something like Talking Parents, which monitors communication. And so what it does is it creates a record of your communications. It's like, I want to say online, it's like $7 a month to sign up for an account. But it's a transcript that will be admitted in court. Text messages can be manipulated, emails can be manipulated, Talking Parents can't. And use Talking Parents like it's going to be read in court, because it likely will, and that's the purpose of it. So we can say, judge, look at this, look at these communications. He was perfectly polite, asking questions about the children, and she's the one who went off on him and started calling him names and getting personally nasty.
Yeah, you got to act like you're going to get a bad reading. I tell people all the time, you should be you should feel like you're being uncomfortably nice in that message before you hit send, because they're going to try to take that one word, and that opposing counsel is going to try to read it in a way that makes it sound like you were screaming at the top of your lungs on the longest rant in the world about how awful a parent they are in front of the children. Yep.
And the good thing about Talking Parents too is it shows when the other person has read, and there's other ones out there. There's Civil Communicator. I'm not sponsored by Talking Parents. I think it's just one of the cheapest. But it shows when the other person has read the message. So I've had cases where, dad's sending messages saying, hey, can I just take kids to dinner? Mom sees it, doesn't respond. Dad sends about, hey, I can see that you saw this. Can we work something out? We can do it. Dad's being great and obviously asking for time, and mom's the one ignoring it. And that puts up me as an attorney. I can go into court and say, why is mom ignoring this?
Persistently kind.
Correct.
You can't say it once and then let it go 3-5 months and not say anything or try to correct it. That's probably the biggest mistake I see men make. Mm-hmm. They wait months before they do anything about it.
Yeah. And, and I do think it's unfortunate in our society that, in a lot of families, it is the woman who's spending more time with the kids, who's going to the doctor's appointments, who's doing the school stuff. And that's because she's the one staying at home and dad's out working to provide for this family. And so, I think, the more years that go by, I start to see judges more and more recognizing that it's not that the dads don't want to spend time with their kids. It's that, they had a mortgage. Mom wanted a Cadillac and nice vacations. So, It is. In some respects, dads are on, they're already having to go uphill from the beginning. But again, like we just talked about, it's a marathon. It's not a sprint. And there might be some battles that you lose. That doesn't mean you're going to lose the war.
Yeah, definitely. That's a great. So we're going to take a quick commercial break here, and we'll be right back with a couple more topics.
You love your children and want them to have everything. How about both parents? Introducing Equal Shared Parenting Benefits Program. The program is very simple. Sign up, download the app, access services. Equal Shared Parenting Benefits Program offers access to medical market, telemedicine, mental wellness, medical bill negotiation and advocacy, chronic care, and a wellness savings program with membership add-ons available soon, like prepaid legal services, prepaid college savings plans, prepaid identity theft protection services, and much more. Annual memberships starting at just $25 a month through Father's Day. Here's what our members say about us.
You guys are a huge blessing in my life. This community is amazing.
I truly thank you for all that you do.
Learn more and sign up at www.tfrm.org. Equal Shared Parenting Benefits Program. It's about the children. They're today and they're tomorrow.
All right, welcome back. I'm excited now to get into more of the strategy and the courtroom execution because as a public defender, you've probably just about at this point seen and heard it all. So with your, yeah, I think only the lawyers fully understand what you've probably seen and heard. With that criminal defense background from early in your career, what kind of perspective does it give you where you've obviously defended people where they potentially could lose years of their lives in prison versus, say, defending a father against a very tenuous domestic violence allegation?
Well, in some respects, being a public defender was easier on that front because you had, beyond and to the exclusion of every reasonable doubt. And you just don't get that in family court. Preponderance of the evidence is the standard. I've heard judges say, well, I think this is credible. So, and that's frustrating. It's frustrating because, obviously losing your kids is awful. I think, in fact, I know I've had clients who would rather go to jail than lose their kids. So that part of it is frustrating. As far as people testifying, preparation is key. I can't say that enough. Doing whatever you need to do to make sure that you're staying calm, make sure that you're being factual again, that you're not taking the bait. It's really easy, especially when, I see pro se parties. It's really easy and they get to cross-examine their spouse or their, significant other, the child, mother or father of their child. It's really hard not to want to go in for the jugular, but it just doesn't play well in court. Not in front of juries, not in front of judges. The more professional you can be about it, the more you can listen. That's something I actually had a conversation recently with a client, and we talked about that. Really, listening is kind of a lost art. People just go up there and they ask their questions, and they're already looking at the next question before they're getting the answer. Listen to the answer. Take your time in court. Judges, obviously, when we're talking about a temporary orders hearing where you've got 20 minutes, that's a little harder. But when we're looking at, the permanent orders hearing where you may have a full day, take your time. Absolutely take your time. One really great thing about Colorado is that the Colorado revised and annotated statutes are online. So you can pull up the statute and get all of the most current case law for free through Lexis. So that's great.
Yeah, that can definitely be a big resource for especially a pro se litigant that isn't dealing with these statutes. I think as an attorney, one of the things you get to hear is you just get to listen to the other attorney's arguments. I like that. I don't like that. You hear that on a regular basis. You see their briefs. As a pro se litigant, educating yourself on exactly what you're trying to prove and being able to or take this evidence is going to help me, or this question and this answer is going to help me prove that. And this piece over here is just me taking a shot at my.
And for people who don't know, the annotated statute means that, so if you have a provision in the statute, when you scroll to the very bottom underneath the statute, it'll have the annotations, and it will tell you every single case from the Colorado Supreme Court, Colorado Court of Appeals that has discussed that provision. And so it will tell you, you know, that a court was wrong in restricting a parent's parenting time because of this, or that the court should have looked at this factor and they didn't. So those are things, you know, you can use to your advantage by, and judges love that because they're busy. And so if you can tell a judge, you know what, judge, I want you to look at in re, you know, whatever, and here's the citation. Oh, you know, judges start bringing out their pens so that they can go look up that case later too.
Box them in with precedent.
Yeah. Well, when I was at the public defender's office, we used to call it closing doors. You close the doors around the prosecution.
Yeah. So I think that segues perfectly into, I guess, step 2 of what I talked about previously. You have the mental aspect, and now I think probably the most important role an attorney plays is building out the strategy. Mm-hmm. So we'll start out with, when a father walks into your office and they sit down across from you at your desk, or I guess over the last year via Zoom, what do you wish they knew before they sat down in that seat?
Just be honest. I want to know everything, the good, bad, and the ugly. Even if it's something that you think is going to make you look like a bad person, I'm not there to judge you. I am there to help you. And I can't be your advocate unless I know everything that could possibly come into play. And I'd rather have somebody tell me more than tell me less, so that I know, okay, so if I have somebody who comes into my office and they say, you know what, she's going to accuse me of doing drugs. And I say, well, do you? I want to hear yes or no. And I want you to be honest, so that if the answer is yes, I can immediately start taking steps. Okay, this is what we need to do to mitigate it, you know, make sure so that she might think she's got this huge bomb she can use against you, but we want to diffuse it ahead of time. So when we walk into court, she doesn't have it anymore.
Yeah, we want to know the bad facts. We want to know those because we can build the strategy around those.
Exactly. Yeah. I want to know exactly what I'm dealing with. Exactly. Yeah. Like you said, the bad facts, I want to know them, and know that everything you tell an attorney, even if you go in for a free consultation, that's confidential. An attorney can't reveal that. So you're in a place where you can be absolutely 100% honest about, hey, maybe these are some mistakes I made in my past, but this is what I've done, you know, and this is what, and also what you want. That's something, sometimes it's, you know, hard to pin people down because they haven't really thought about, you know, what do you want? And is it feasible? You know, if you want week on, week off, okay, what is your living situation? Because that's something a judge is going to look at. Or if we have a child and family investigator, which we use a lot in Colorado, and they're appointed by the court to do investigations on what is in the best interest of the child. And they come up with a report and they submit it to the court. And the court, I would say 99% of the time, is going to follow the CFI's recommendations. So, but those are all things the court is going to look at. So start thinking about that. You know, if you work the night shift, you know, what's your plan as far as having your kids? Are you going to have a daycare? You know, how would that work? Things like that. Really, what do you want? And tell me the good, bad, and the ugly.
Yeah, I got 2 points on that. One of the most expensive mistakes that a client makes is not disclosing all of the bad facts. Mm-hmm. And then you draft up a declaration, you build out a strategy, they get a little bit more comfortable with you, and then all of a sudden they start talking a lot more, and it's like, okay, what we planned isn't going to work anymore.
Yeah, exactly. And cooperation too. I mean, that's something that, you know, pay attention to emails from your lawyer or their paralegal, because at least in Colorado here, it's all of these, it's very document heavy, a lot of financial documents that need to be disclosed. We typically do written discovery in cases. So pay attention to that, even if you're a pro se litigant. And that's one thing too, Colorado holds pro se litigants to the same standard as attorneys. So you are going to be expected to know the rules, know what has to be disclosed, know what the deadlines are, and it is all available online, but you are expected to know it. So that's something to remember as well.
Yeah, and then I'll make one last point on something you said, and it's actually come up all the last 3 weeks now. One of the strongest privileges that exists is the attorney-client privilege. Mm-hmm. So it's not like if you come in for a consultation, or let's say you retain the attorney and then you decide to go in a different direction. We can't go tell your spouse. We can't go tell opposing counsel. We can't go around town talking about it.
Exactly.
It has to stay in that office. Mm-hmm. And I thought Joseph Emmerich from Illinois was on last week, and he put it very succinctly. I don't care about your case enough to lose my law license.
Exactly. Exactly. I worked really hard and paid a lot of money for this license.
Yes, exactly. So now we're moving on to, we talked about getting the bad facts out of there. And I use in strategy, I use a football analogy. I find that most guys work really well with that. I know your husband is a football coach, yep. But I talk about, like, we have to scout offensively we have to scout your defense. We have to scout the opponent's offense and defense. And we have to look at, hey, what audibles are we going to need to put in place in case we need to use them?
Yeah.
So
and be upfront about it from the beginning, because we are thinking strategy from the first time you step into our office. Okay, this is what we need to do. These are the types of hearings that we're going to have to set. Did I just freeze? Oh, okay. You know, they from day one, I'm already thinking, you know, okay, if we end up at permanent orders, this is what we're going to need. And a lot of the disclosure requirements in Colorado, we're disclosing witnesses well before we go to trial. We're disclosing exhibits well before we go to trial. And we're thinking, so in Colorado, you have to file what's called a joint trial management certificate, typically 7 days before the trial itself. We start drafting that on day one. We start, you know, anytime, okay, this fact, okay, let's start doing this. And those are all your positions, and then you incorporate the case law in that as well. And that's something that the judge is going to read several times before you even go to hearing. So you want it laid out in such a way that there are things that the judge is going to remember. Oh, I remember, you know, Ms. Mitchell brought up that statute or that case law that's applicable here. And now I'm listening to that testimony that ties it all together. So, yeah, so I mean, that's not, and that's something that I've had issues with sometimes is people, you know, the 3 days before trial, oh, I forgot to tell you. Yeah, no, I need to know as soon as possible. And the more, the better. We always tell our clients, tell us too much. Tell us, give us too many documents. I'd rather have more and let me sort through what is important as far as our strategy, than not have enough.
Yeah, because I mean, as attorneys, these judges having so many cases, we're really looking for 3 to 5 key points that we're going to just continue to hammer home. Mm-hmm. And we want to do that from the first hearing. We want a pattern to develop in a judge's mind around the case. And if you don't disclose things to us, whether they're good, they're bad, if it's bad, and all of a sudden that's one of our 3 main pillars we're arguing in terms of getting you what you want, all of a sudden, like, that's just knocked down at the last second when we've tried to build this pattern in the judge's mind. And the other way around, if you give us something you thought didn't matter, then we find out 3 days beforehand, it's really limited what we're able to do with that piece of information.
Exactly. Because then you got to remember too, for attorneys, there are rules about when, you know, I can't walk into court and blindside the other side with some piece of evidence without a really, really good reason, because the judge is going to say to me, why didn't you disclose this 30 days ago, like when you were supposed to? So you got to keep that in mind too. And that comes down to communication too. I hear horror stories from people where they, you know, hire an attorney and then don't hear from them for months. Remember, your attorney works for you. So, you know, not, you know, and I get it, attorneys are busy, but it takes, you know, 5 minutes to respond to an email. So, and most attorneys, I have 2 paralegals that are fantastic, And I always tell my clients, when you email me, CC my paralegals too, so that if they can't answer the question, they're calling me or texting me saying, hey, did you respond to this email?
Yeah, definitely. That's something I think you see more frequently in family law, and I haven't put my finger on why. Is there are just some attorneys who aren't necessarily as responsive, and that may be a sign early on that maybe you need to go in a different direction.
Yeah, exactly. And like I said, your attorney works for you, and we are busy. I mean, I'm not going to lie. In Colorado, I'm setting hearings right now for mostly January and February, so that's how busy we are here for setting for final orders. But really, there's no excuse that someone in the office can't get back to you.
Yeah, definitely. So on the last piece on the case strategy, and we've talked pretty in depth about it. So what are some tips that you would give represented fathers in terms of working with their attorney to build a strategy, and then also the pro se dads that are trying to do it on their own?
So, well, as far as represented people, it can be hard to let go of control to somebody, and I think that's where communication and a good rapport with your attorney comes into play, where you can talk to your attorney and say, hey, these are the goals I'm trying to achieve. How do we get there? But, if your attorney says, well, this is the case law and this is what, then, in some respects, you do have to defer to your attorney, because that's why you hired them, is for their education and expertise. I think something too, I'm starting to see sort of here in Colorado is, you do get attorneys sometimes that dabble into family law. In my opinion, family law isn't something you dabble with. You either do it primarily or you don't, because, things are changing. There are always laws that affect things, at least here in Colorado. So you need to know what you're talking about and need to know the most current case law. As far as pro se people, obviously it's a little more difficult, but again, like I said before, recognize that you are going to be held to the standard of an attorney. So you do need to make sure that you know the rules. You need to make sure that you know that there are certain deadlines for filing things, that there are certain, for instance, in Colorado, we have to confer. And that means before you file pretty much anything, you have to reach out to the other side and say, hey, I'm going to file this motion. What's your position? And you have to put that in your motion, because that's something I see pro se people get hung up on all the time. And judges don't appreciate that, because there's a reason for that, is to see if there's something you can work out instead of just inundating the court, which is why we're setting in January and February right now. So know the rules. That's a big thing. Know the case law, do your research. And, I think too, always bounce ideas off of people and see how it sounds, people that you trust. Because like I said, judges are human. So a lot of times, I'll bounce stuff off, maybe my husband, like, hey, if, in this theoretical situation, how does this argument sound? Does this make sense? And he can tell me from a layperson's standpoint, because I feel like if another layperson understands what you're saying and it's clear, then a judge is going to understand it as well. So, and practice your arguments too. Lawyers still, I still practice, in my head, write stuff down, bullet points. This is what I want to argue to see how it sounds. And that's another thing too. I see pro se people come in with written questions and they're just beholden to those. The case better than anybody. Come in with bullet points, have some flexibility, but remain calm, and get the facts across, because that's what the judge is looking at, facts and law.
Yeah, preparation piece. I'm always a big fan of having that one sheeter that it's, okay, this is the purpose of the hearing. This is what we're going to argue. Here's the strengths. Here's the weaknesses. Here's their strengths. Here's their weaknesses. They're probably going to argue this. We may need to call this audible. It's right there, all on one page.
Exactly. And also, the big thing, know things like hearsay. It gets thrown around on TV all the time. Doesn't mean what a lot of people think it means. I think some attorneys, in all honesty, some attorneys don't understand what hearsay is. But so no, if you come in with this stack of exhibits, that, you might not necessarily have to or be able to just hand them to the judge. You're going to be expected to lay foundations and make sure that they comply with the rules of evidence, at least here in Colorado. Also have copies for everybody, copies for the judge, copy for the other attorney. Share things ahead of time. I see a lot of pro se people come in with, a stack of documents that I haven't seen. And the first thing, of course, as an attorney, I'm going to do is object because that hasn't been shared with me. Some judges will say, okay, we'll take a brief recess, share that with her. And some judges will say, you know what, you didn't share it, so you don't get to use it. And that again comes down to knowing the rules, which again, even, if you can't maybe afford an attorney, there are things you can hire an attorney typically at a lower rate to do what we call, in Colorado, a Rule 11, where we might draft the pleadings for you. We'll help you with, strategy and things like that, but we don't actually go to court with you, but we'll tee you up for court. And so that's something you can talk to an attorney about doing at a lower rate.
Yeah, and I think the big thing for litigants, you have to realize all the rules of the courts are designed that nothing's a surprise when you step in front of the judge to either party.
Exactly.
So being afraid of reaching out to opposing counsel and saying, what's your position on this? Or sending them the documents ahead of time. Your rules of civil procedure in each state, and depending on the type of hearing, will lay out exactly how many days you're supposed to get opposing party those documents. Everything's designed to not be a surprise.
Exactly.
And to be honest, if it's gonna be pro se litigant versus an attorney, and we're just gonna make a bunch of surprises, it's just gonna be whatever goes. The attorney's probably gonna win, just because a lot of family law stuff works on pattern.
Mm-hmm.
It's gonna go A or B, and we know that, and you have no idea.
Yep.
So now we'll move on to the next piece of it. You've built out your strategy, and now we're ready to step in the courtroom. So I think we covered it a little bit earlier, but testifying plays such a huge role, whether it's the judge is just asking you questions and you're sitting down by your attorney, or whether you're actually getting up on the stand and answering some questions from opposing counsel who's probably going to try to needle you and get a reaction out of you. What are some tips and tricks and advice you give to dads that when they know they're going to have to go up on the stand, or it's a judge who is just going to turn and ask the party themselves a question?
Most of the judges here don't ask questions of the litigants. They let the attorneys and the parties handle that. Every once in a while, you might get a judge jump in, but at least here it's going to be mostly either your attorney questioning you, or if it's someone who's pro se, the judge is going to have you take the stand and give a statement, essentially. So the big thing is, again, know the rules. Don't start talking about things that someone else told you unless it's the other party, because what the other party has told you can come in, but what other people have told you outside of court, my son's therapist told me this, that's going to be, especially if you're up against an attorney, it's going to be objected to as hearsay, and it's probably going to be upheld and sustained. So don't put yourself in that situation. So make sure, that you have something prepared. And again, that comes down to bullet points, your theme, what you want, what you've set up, what you want the judge to know. A lot of it's preparation. And then, think of it personally, what you need to do to remain calm. I always tell my clients, think of the big picture, because she's going to try to provoke a reaction, because her argument throughout has been that you're this, angry, hostile person. And so that. So think of the big picture, think of your kids. Don't buy into that reaction. Just do whatever you need to do to stay calm. Some people have certain hand things or whatever. Stay calm and be prepared. And if you have an attorney, they should be prepping you for hearing. They should be talking to you. Okay, these are the questions I'm going to ask you. These are the exhibits I'm going to show you. And be prepared with that too. That's, if you're a pro se litigant and you're up there giving your statement, what exhibits do you want to introduce as part of your testimony? And have those exhibits marked and prepared, and have extra copies. You want one copy for the judge and one copy for opposing counsel.
Yeah, I had a mentor, and I still use it to this day, really in any interaction I have. But he always used to say, when you're in those tense situations, before you speak, it's in through your nose, out through your mouth. Breathe in through your nose for a 4 count, and then a slow, deep breath out before you start to speak. Gather yourself.
And when someone asks you a question, take a pause, take a moment, think about, number one, what they've asked you. And that's a big thing you see on the stand. You know, someone gets asked a yes or no question, and they go, yes, but, and they go off on this whole tangent. The answer should be yes. Yes or no, if it's a yes or no question. And that's where people get into trouble, because they start elaborating, and then it becomes this whole back and forth. And you can avoid that if you just take a moment, listen to the question, and then answer.
Yeah. Yep. That's definitely a big one. I think with men more than women, needing to explain when they haven't asked for an explanation, and it's only going to make you look worse.
Yep, exactly. Whereas women I see with arms crossed, yes.
That or the waterworks.
That's a whole separate show.
Yes. All right. So we got some questions that I have pulled from my DM. So thanks to all the viewers that dropped some questions. I know I announced last week it was going to be Colorado, and we got a couple questions that are specific to Colorado, or at least you probably get as well. So the first one, let's talk about weed. So we are both in states where weed is legal. I've gotten it twice this week, where either in consultation or a client or whatever it may be, even just in conversation with someone who thinks they're going to be maybe going through a situation, where they ask the question, does it matter if I can't pass a drug test that would include marijuana?
So it depends on the situation, and it's going to depend on your history. You know, obviously marijuana isn't known for causing a lot of violent offenses. But, you know, there are situations where a judge might order alcohol testing. Alcohol is also legal. So think of marijuana like alcohol. That's how we think of it here. So if it's someone who's had, you know, a demonstrated pattern of substance abuse that has led to all kinds of issues, the likelihood is a judge is going to say you shouldn't be taking anything. If it's a situation where, you know, maybe you've got, you know, medical reasons for taking marijuana, get that in writing from a doctor, get a red card, get a prescription, you know, because that changes things. If you have a doctor saying, well, he needs to take this marijuana for his anxiety or, you know, nausea or something, that's different. And it's easier to go in front of a judge and say, Judge, I don't use this. I take an edible at night. I'm not, you know, doing this during the day. But yeah, I think of it as alcohol, but it really is, again, a lot of Colorado is very, very fact specific.
Yeah. I'll hear, I guess it's something that's a little bit newer. And it always tends to be individuals who there may be some substance abuse allegations in the past. And a lot of times, if that's the case, it's like, hey, there's a chance they're going to order that hair follicle test. Let's go ahead and be safe. And like, if the judge asks, and can I confidently say, yeah, we'll do that. Yeah. And it can make it a lot easier, especially if there is the documented substance abuse issues in the past. Like, remove that. You know that's going to be argument 1A for your co-parent. So let's go ahead and let's just remove that. They're going to lead with it. And then, hey, do we walk in with a hair follicle test, or do we say, yeah, Judge, we'll do that right now? Like, he'll leave here and he'll go get it done right now.
And the reality is, what I've seen here is most judges will say, okay, yeah, I'll order a hair follicle test for him, and I'm going to order one for you too. So if they're going to do it for one, they're typically going to do both. So that's something to keep in mind. But I mean, Colorado, I'm not going to lie, especially the metro areas, Colorado Springs, Denver, they're pretty relaxed when it comes to marijuana, no pun intended. But, you know, you got to think of it as alcohol. So it'd be the same thing if someone walks into court and they've got a demonstrated history of alcohol, they've got a bunch of DUIs, judge might put you on sober-link. Marijuana is no different. So think of it like that.
Yeah, I think that's definitely a good way. Very judge dependent too. If you end up with the 80-year-old that's been on the bench for 30 years that hasn't looked at the family code for 15 years, they may bring the hammer down on you like they would have 15, 20 years ago.
Yeah, whereas if you get the judge in Denver where shrooms are legal now, they're probably not going to care. It just depends.
Yeah, that's bringing back memories to me right now from just the stories we could tell. But okay, so we'll move on to the next one. So this is a very, very common one, and this one was actually asked Colorado specific. I'll address California after you address Colorado. But what do I do if my co-parent is refusing my visitation in violation of the court order?
Okay, so we have a court order in place and they're refusing in violation. So in Colorado, you have two different avenues you can take. You can file the contempt, which a lot of people do, and people come into my office, I want to file for contempt. I am not a big fan of contempt, and here's why. In Colorado, because it's quasi-criminal, when you file for contempt, the court is going to first review the motion. They're going to decide whether or not they want to issue the contempt citation. I've had it take, a matter of days or several weeks before that gets issued. Once that gets issued, you have to have it served on the other party. And there are time frames for when you have to have it served. The court is going to set it for an initial appearance, basically where they're going to read them their rights and explain it to them. Then you're likely going to be set for mediation. And then maybe 6 to 8 months from now, you might get a hearing on it. But
the defender's office.
It seems to depend on the county. Some judges will appoint the public defender, other counties won't.
What's the penalty in Colorado on contempt?
It can be up to 6 months in jail.
Gotcha.
But I have yet to see anybody go to jail, I'll be honest with you. Another reason, not a big fan of contempt. So under Colorado law, you can also file called a parenting time dispute, and it's under 1410-129.5. And if you look at that statute, it has very firm deadlines in place where a court has to either, if they think that there is a legitimate issue, they can make a ruling or they can set it for hearing. A lot of times that forces judges to set it for hearing, and they have to set it, I believe it's within 35 days. So it keeps it on a very short leash where you're likely going to get a hearing much faster than you would on a contempt. And here's the great thing about 129.5 is when you get to hearing, the judge finds that that person should be in contempt, they can still hold them in contempt. So it's still a remedy. There's a list of remedies available to the judge, including contempt, including, they could have to pay bonds to the state in case there are future violations. It also gives the judge the power to modify a parenting plan. So let's say, mom's been withholding the child, not adhering, and, dad only has every other weekend. A judge can look at her and say, well, if you're going to do this, then I'm going to give him more time. I'm going to modify this parenting plan. So
you have a fast lane in Colorado.
Yep. So my office, I'll be honest, we rarely file contempts anymore. We file 129.5 motions.
Yeah, that sounds like it's really a no-brainer in terms of benefit to the client, because those contempts, when it becomes that quasi-criminal, there's a lot more rules that we'll say get followed when that gets drug into play.
Exactly. And also when you go to court on a contempt, and if you're asking, so Colorado has two types of contempt, either remedial or punitive. Remedial is obviously you're asking the judge to fix something, to do something, make it right. And punitive is where the jail time comes into play. Remedial is preponderance of the evidence. Punitive is beyond a reasonable doubt. So you're acting essentially as a prosecutor. So the 129.5, like I said, I file them all day.
Yeah, that seems like Colorado is very progressive in some of the laws they've implemented in terms of the parenting responsibility. Instead of talking about custody and visitation, knowing that following the order is going to be a major issue and creating an avenue to handle it that isn't winding through what usually happens with a contempt process.
Exactly. Mm-hmm.
All right, so we're closing in on an hour here, so don't want to take up too much of your time tonight. So I want to ask one last question. So in terms of for all our viewers, most of them are going to be fathers or people in the support system of a father or their son or their new significant other, whoever it may be. What advice would you give to a father who may be just starting out or one that's been maybe in the process for 2-3 years? What advice would you give them to help move forward in a positive direction?
Just hang in there. I do think that the truth comes out eventually. Like I've said a couple times, this is not a quick process. It's a marathon. And the reality with, here in Colorado, you can reopen if there's a, change in circumstance. There's lots of reasons that you can reopen custody, parenting time, not custody. So there's, it's a long road. So I think number one, take care of yourself first, because you can't be a good parent unless you are good to yourself. And then, other than that, think of the best interest of your kids. What is in your kids' best interest? And just don't give up. Don't stop fighting. It's hard. There's a bureaucracy. There's a process. Like we talked about earlier, there's all these rules, but don't give up. And seek the advice of an attorney whenever you can. Lots of attorneys give free consultations. Take advantage of that. Take advantage of the resources online. But, that said, the legitimate resources, be careful, because I've seen some just outrageously wrong information sometimes in comments. Lots of attorneys give free consultations. Go get one.
Your husband and I have had that conversation about the Facebook groups. A lot of Google lawyers, when there's free 1-hour consultations where you can go talk to someone who's been in the trenches and has seen what actually happens.
Yep. And I know lawyers that'll, write up the strategy. They'll put what they would do down on paper for like $100-$150. There's lots of divorce lawyers. You get a couple free consultations. Why not? Shop around and make sure, if you do hire someone you have a good rapport with and that you trust. But yeah, talk to a lawyer. It's, like I've said a couple times, it's so fact dependent, so much of this, that the best thing you can do is talk to a lawyer, even if it's just that free 30-minute consultation, and they can guide you. Hey, this is what you'll need to do. This is what you'll need to file. Here's where you can find, here's the rules for this court. Here are the local rules that you have to be aware of.
Yeah, I've seen some of them. They will give you, California is very form heavy in family law, and there will be attorneys who, if they have the packet, and when you say, like, I would love to work with you, but I just can't make it work financially right now, they're like, hey, you need to do something. Here's the packet you need to file to get your divorce started.
Yep.
So
the Colorado courts have every single form, not just for family law, but for anything online. So if you go to the Colorado court website and go to self-help forms, everything is there. For family law, they have flow charts. Do you have kids? Yes. Do you have no? So that it takes you through the whole thing. And almost every single county has a self-help center that you can go to, and they will actually help you fill out and file the paperwork.
Yeah, and that's another very positive development. I think there is a couple counties in Southern California here where they have automated the initial filings. So you create an account, and it just asks you questions, and it fills out the forms for you. And a couple of the systems you can submit right through there. Like you put your credit card information and you submit right there. So, because I know it's California, it can be a mess. It's like, oh, I need to attach FL1 whatever 109 now, or whatever it may be. There are a lot of states now have where you can go in, and it may not be your county, but you could probably find one where you can just answer questions, and then it'll allow you to download the documents.
Yeah, well, so in Colorado, like I said, all the forms are online. You can download them either in Word or PDF. And then we use an electronic system called ICCES. We call it ISIS, not the best word. They've tried to get us to stop saying that in court, but old habits die hard. But pro se litigants for family law cases can register for an account for ISIS and file everything online.
Yeah. Wish it was like that in California. There are some counties where it's, at this point, the courthouses aren't open yet, so it's snail mail or fax.
Oh, geez.
A majority of them, there are ways to e-file.
Yeah, the only one that is going to require you to go to the courthouse or mail in a document is JV court, which would be paternity actions, typically start in JV court here. And it's because everything's sealed. So ISIS, you can go online, you can buy into cases, and some of the documents are public. Anything that has any sensitive information is going to be sealed by the court. But if you have an ISIS account and you are a party to that action, you can see everything that's filed. You can also serve the other side. So if you're a pro se litigant and you're up against an attorney, there's a section for serve only documents. So if there's letters or information so that you've got a record there, hey, I told this attorney about this 30 days ago or 45 days ago.
Yeah, definitely. All right, so as we wrap up here, so you service the Denver metro area in Colorado Springs, correct?
Correct. Yeah, so that's everything from Jefferson County to Adams County, down to El Paso, sometimes Pueblo. We've even gone as far north as Weld and Larimer. So anybody who's in Colorado listening will recognize those counties.
So if you're in those areas, you're in the market looking for representation, how can they get a hold of you?
They can get a hold of me through C. Robert Bandino Jr. Is my partner that I work with. Our website is divorcelawyersdenver.net.
All right, so divorcelawyersdenver.net.
Mm-hmm. Yep.
Okay, awesome. We'll have that in the comments for you guys. If you are in the Denver area and you are Denver metropolitan area or Colorado Springs looking for representation, reach out to Heather. I'm sure she'll be able to at least put you in the right direction, or you'll be in great hands. So, Heather, thank you so much.
Sure. And I can give you a phone number too, if you want a phone number.
Go ahead. Yeah, go ahead. Drop us the phone number as well.
Sure, it's 303-931-5516.
Perfect. Okay, we'll drop that in the comments as well too, so you can give her office a call, or you can check out the website and get in touch with her there. So, Heather, thank you so much for your time and all the value you provided to the viewers tonight. Thank you so much. And to the viewers, we'll go back live here.
All right, great. Thank you.
All right, guys. Hope you enjoyed tonight's episode with Heather. A lot of value around what's going on in Colorado. Also, we talked about the mental aspects of going through the family court, strategy, execution. I hope you enjoyed it. Once again, appreciate Heather for taking the time to be able to film that last week. Next week, we will be going back live with our episode. We will be having Houston, Texas attorney Cassandra Daniels on the show. So if you're a father in Texas, definitely a must-watch next week, where we'll be talking specifically about the state of Texas and all of the different things that are going on down there right now. I know it's been an adventurous state over the last 2 to 3 months in terms of legislation. So we'll have Cassandra on next week. Thank you all for watching, and we will see you next Thursday on State of the Family Courts.